Hello viewers. Justice is one of the main objectives enshrined in the preamble of our Indian Constitution. Though many judgments have made preamble to be an integral part of the Constitution, preamble cannot be considered as a one single point source for the interpretation of any law, and it is non-justiciable. Why I'm stressing about the preamble is the recent Supreme Court verdict again legalizing the same-sex marriage has brought gender justice into the spotlight. Hello everyone, I'm your host Madhusudan from National Defense Institute. Today in this video, we will be discussing about the recent issue regarding the same-sex marriage. So in this video, we will be mainly discussing about the actual things that is displayed in the overview. So what are the issues are? Mainly, we will be discussing about what is the issue and what is the verdict from the Supreme Court and what are the takeaways from this verdict. And we will be discussing about based on that verdict, which is the community that has been actually affected or which is mainly under the contention, the LGBTQIA plus. So we'll be knowing about that community and what is that acronym is mainly deals with, and we have some of the claims from that community. So what are the claims they are making for petitioning such a case, and also what are the earlier judgments that have been done in favor of the LGBTQI communities, and the main issue about the recent judgment or the recent stand of the Supreme Court in arguing against the same-sex marriage and what is the best way forward. So this is how the video actually goes. So let's see what is the actual issue. So usually, recently, in the last week, the apex court has refused to accord the recognition for the marriage between the persons of same sex. This has made a large legal setback for the queer community. In the time of deepening the individual rights, for example, making the right to be a more privileged one, making or increasing the amplitude of the Article 21, including the privacy or the education or the information, this verdict has given a setback for this LGBTQIA community. So let's see who are those LGBTQIA community and what is their meaning. So before I explain this, I just want to confirm that this video is mainly for the information and knowledge purpose, and there is no stigma attached or any prejudice for the respective community. Having said that, let's see what is this actual means about. L is nothing but the lesbian. So lesbian are the female who are attracted to the same gender. Similarly, gay is nothing but the male one who is attracted to the male or the same gender person. And bisexual is the one which is actually a person who is actually attracted to either male or female. So irrespective of the gender, he will be attracted to the both one, he or she. That is what we mean about the bisexual. Transgender is the one who is having a sexual identity which is different from the identity which is having at the time of birth. That is one we call them as a transgender. And queer community. Queer community is a some sort or the term used for a umbrella purpose, or it's an umbrella term where exactly the sexual orientation or the identities still have a confusion among themselves. I mean, they don't have a proper clarification with respect to their sexual orientation. They are grouped under the queer. And the intersex. Intersex is the one who is having a different sex characteristics apart from the binary definition of what actual gender have. That means with respect to male or female. So they have multiple sex characteristics of any genders. That is what we term it as your intersex. And asexual. Asexual is the one who is not attracted to any of the genders. That is what grouped under the asexual. Then plus. Plus is nothing but the genders or the section which is not actually grouped under any of the said terms. That is what we term it as your LGBTQIA plus. So having said that, they actually made some claim. So what are the claims for making the legalization of the same-sex marriage is, the very first thing what they told is to make a gender neutral interpretation of the Special Marriage Act. So before going to the gender neutral interpretation, what is Special Marriage Act? It was enacted in 1954. This is purely made because to give a secular legislation for the interfaith and interreligion marriage. So this has given effect for that, and here that is mainly treated for the, or the words is respective with respect to male or female. So these petitioners are claiming that that word with respect to gender has to be a gender neutral, so that the interpretation will be more broader and the same sex marriage can be brought under the ambit of the special marriage act. That is what the claim they are making. So having said that, the main thing what is the claim, or the petitioner's claim has been struck down. That means judiciary's verdict is purely against their claim, but it doesn't mean that their judiciary has not even taken the interest in securing the rights of the LGBTQA community. There are many judgments where their rights have been embraced. For example, as you can see in the slide, there is something called earlier judgment where this NAS Foundation versus Government of New Delhi, I mean the NCT Delhi, has declared, that means the High Court of the Delhi has declared that Section 377 as an unconstitutional. What is Section 377 is? It is nothing but criminalizing the same sex. So in order to reduce the discrimination or to embrace the conjugal rights, that 377 has made it as an unconstitutional by this judgment. And similarly, one more judgment was National Legal Service Authority versus Union of India, where in this judgment the transgenders were actually recognized as a citizens of India like other genders, how they are exercising the fundamental rights. Even they will be exercising the similar fundamental rights, and also they can be considered as a third gender. That is what the NALSA versus Union of India case judgment actually tells. Similarly, another important thing, another important judgments what actually said is, one is Justice Retired KS Puttaswamy versus Union of India. This is one of the landmark judgment where the right to privacy was brought under the Article 21, so that irrespective of the gender, the privacy has made been a upper hand, so that the LGBTQ community have some sort of unique traits and also some of the unique gestures and their attire. So their those cultures should not be actually prejudiced. In that angle, their privacy is also important. So this Puttaswamy case has actually made their rights to be on par with the normal genders. And another important thing is Navdeep Singh Johar versus Union of India. So this case actually has a revisit with respect to the Section 377 and made a decriminalization of this 377 and make sure that is throughout the India, this 377 has been made as a decriminalized manner. And last one is your Arun Kumar versus Inspector General of Registration, Tamil Nadu. So this is one thing where it has expanded the usage of category of women in case of any of the bride purpose. So instead of women, we can also use the transgender people to identify them as the bride, so that if there is any dowry or if there is any case of domestic violence, they can also be addressed. So this is the main idea with this judgment. So with that, there is something what we have to say is, especially the interest of the transgenders has been secured majorly by the law that has been enacted. What you mean about it as a Transgender Persons Protection of Rights Act 2019. So this is something where enacted, but there are certain ambiguities even in this act. So what we have to say is, we have to wait and watch whether the ambiguities in this act also will be resolved in the future days. So, but the very important point is the recent judgments of the Supreme Court. So what do you mean by these recent judgments? What actually the points or arguments the Supreme Court has taken to bat against the against the legalization of the same-sex marriage? So very first point it is telling is, there is no fundamental right to marry. What is this mean is, for example, if there is any law that is going against a fundamental right or abrogating any fundamental right, the law can be struck down as per the Article 13, and even a judiciary can take a judicial review in order to make that law as an unconstitutional one. So what Supreme Court is telling is right to marry itself is not a fundamental right, because it has stated that marriage is fundamental to fulfilling a life, but it is not a fundamental right. So whenever there is no fundamental right to marry, judiciary cannot intervene in order to struck down the law. Law means what I mean about the Special Marriage Act. So with that, what it is telling is it cannot be taken in case of a gender neutral, or also it cannot make right to marry as a fundamental right. But judiciary, whenever there is a need, has shown in activism in order to make the amplitude of the Article 21 into a higher level. For example, right to education was brought under Article 21, and it was included by 86 Commandment Act as a Article 21A. And similarly, right to privacy and right to internet, they are all something which Article 21 has been expanded, but right to marry is still held as a statutory right yet. And the another argument by the Supreme Court, what it has said is in favoring or going against the same-sex marriage, is it cannot strike down the Special Marriage Act, because it has told some of the reasons why it cannot strike down the Special Marriage Act. As I told you, the claim by the petitioners was to make the Special Marriage Act as a gender neutral. But if the gender neutral, and they claim that since it is not gender neutral, it is against right to equality, that is a one of the fundamental right. So when it is against the fundamental right, that law has to be struck down. But what Supreme Court said is that Special Marriage Act has given effect for interfaith and inter-religion marriages, and when that act was enacted in 1954, Article 377 was not decriminalized. In that effect, they can tell that Special Marriage Act cannot be struck down. If at all it is made it as a gender neutral, the interfaith marriage and inter-religion marriage effect will be dissolved. When that is dissolved, obviously India will be entering into a conservative society rather than being the secularization society. That is what here we mean about entering into the pre-independence era. So it is more of a backward looking than a forward looking. So in order to make a place towards the forward looking, we cannot strike down the Special Marriage Act. That is what the Supreme Court said. And another important thing is the complexity of other bouquet of rights. What is this complexity of other bouquet of rights? See, for example, if the Special Marriage Act is made as a gender neutral, then what happens is there are other web of legislations, that means the spider web of legislation, that will have a cascading effect to the almost 160 laws. So for example, succession act or inheritance laws or adoption laws, these are certain things that is going to be affected. One such example what I want to give you is the Central Adoption Regulation Authority has given guidelines for the adoption. That is nothing but the CARA guidelines. What it says is, in order to adopt a child, one has to be a married, or the unmarried one will be allowed to adopt only the respective genders. For example, the male can adopt a male child and a female can adopt male and female if they are unmarried. But in case of the married couples, they have to have at least 2 years of stabilized relationship. Why is that? Because if the marriage relationship is divided, who will be the actual caretaker for the child? So in order to make a child welfare into the central spot, the Juvenile Justice Act has enforced such laws. So keeping that in mind, that is one law. So LGBTQ communities are not allowed to marry in a between the same sex. When that is the case, their adoption will be also in a difficult manner. So in that scenario, what complexity arises with respect to adoption will be similar to almost another 160 laws. This is what one example I told you, and that is nothing but the complexity of other bouquet of rights. So that is another point what Supreme Court said. And along with that, one more thing what he said is, we cannot read the Special Marriage Act, because the reading of any act is the duty of the legislature. If at all judiciary is doing that, it is entering the realm of the legislature. So these are the basic points what it made to make sure that it cannot strike down the Special Marriage Act. This is the one type of another argument what Supreme Court judge did. So, additional with that, it has not at all withdrawn or made the rights of the transgender peoples into vain, but it has ensured that the rights of the transgender peoples are still secured. Where, for example, the heterosexual relationships have given a safe harbor. That means they have the right to marry with the existing law. For example, a trans woman can marry a trans man. That means that is what I mean about the heterosexual relationship. But a trans woman cannot marry a trans woman. That is the same sex marriage, what the Supreme Court is not allowing. So the rights on the transgender persons to marry is still valid, but only in case of a heterosexual relationship, but not non-heterosexual relationship. And lastly, what Supreme Court is trying to say is with respect to civil union. So, what do you mean by a union? So, if you see, as per the article, as per the part 3 of the Indian Constitution, making or forming a union is a fundamental right. So, in order to make a fundamental right, the state has to recognize that union. For example, marriage has been recognized as an institution where the that has been recognized by the state from an Hindu Marriage Act or Special Marriage Act. But in case of the LGBTQI civil union, that is not at all recognized. So what Supreme Court has said is, if at all that civil union has to be recognized, or they can exercise the fundamental rights to make the union like other genders or on par with other genders, first state has to recognize that union, then only they can exercise their rights and reap the benefits of forming the union. So that is what the Supreme Court is telling, and it has directed the state to recognize the such a unions with respect to the states, and so that they can grant the benefits under the law. So this is what another point they made. That means what I'm trying to tell is Supreme Court has not at all completely divided the rights of the LGBTQI community, but it has also safeguarded some of their interests. Having said that, I just want to tell in the last slide what is the best way forward. As we know that our Constitution is a living document, and our forefathers has made space for the evolving changes and any of the trending challenges to be accommodated with respect to the interest of the people. So with that, judiciary has its own activism. Wherever the sensitive issues are there, judiciary has shown its restraint and let the issue to be decided by the people. So such kind of a one sensitive issue is this same-sex marriage, and for that, judiciary has not become much hyperactive, but has shown this restraint and make sure that the majority people's will has been prevailed. So now it has let the issue to be decided in the parliament, and we have to wait and watch how the parliament is going to make the decision. And even the LGBTQI community has to wait and watch so that there will be enough security for their rights, and things will go unfold in their way, but only when the society accepts. Because any law which has been made either by the legislature or by the executive or by the judiciary, it is not at all accepted when the people's will is not ready to accept it. So it will be left it only as a lip service. So everyone has to wait and watch to make a social acceptance, and government will obviously take a step in that direction. Having said that, I will wrap up the video. So kindly watch for the subsequent videos and do subscribe for the channel. Thank you once again.